This podcast features criminologists discussing sensitive themes and topics. Listener discretion is advised.
A repeat offender is deemed unfit to stand trial and released into the public. For one aspiring young musician, this court decision would prove fatal. This is the Jillian Ludwig story. Hey, Meghan.
Hey, Amy. I'm curious already because I see a problem with the introduction here to this case. I just want you to know.
Yes, you're definitely going to love this case, not because obviously it's a very tragic case. I mean, the legal issues that are brought up in this case, I think will have us going for quite some time. But I have to say, I need to give a big thank you to somebody very special who recommended this case. I'll give you a hint. She is our #1 fan. She always gives incredible feedback. She has been a supporter of the show since day one.
I know it.
And I am related to her.
Yes, I knew exactly who it was after you said she gives us feedback, too, because I know she does. And it is your sister-in-law.
Yes, my sister-in-law, Jules. As always, thank you so much for your support. And thank you again for bringing us this extremely important case today. Very tragic, but it sets the foundation for some pretty interesting conversations. I think you'll see that.
I can already see that from the title.
Yeah. All right, Meghan. So let's meet Jillian. Jillian Ludwig was born on December 31st, 2004 in Brick, New Jersey. Now, Brick, New Jersey is super close to me. It's in Ocean County, which is about 25 minutes south. Jillian had a very loving and close-knit family. And besides her 2 parents and her 2 brothers, she had a very large extended family of aunts, uncles, and cousins whom they spent a lot of time with. Around the age of 5, her family moved to Wall Township, which is only a little bit north of where they lived before. And Meghan, Wall Township is actually the area that is known as the Jersey Shore.
Oh.
I'm sure you know all about the Jersey Shore.
I would never have known the name, the original name. Okay.
Yeah. I can assure you, though, that this is not like the Jersey Shore that you've seen on TV. It's a very family-friendly, beautiful place to live.
Okay.
Jillian thrived there. From a young age, she loved music, and she was extremely involved in her community. She often sang the national anthem at township community events. She also sang and played guitar for her church.
Oh.
Her love of music would continue well into her teen years as she studied music at the Manasquan Music Academy before becoming deeply involved in Asbury Park's Lake House Music Academy. And here she not only sang and played guitar and bass with multiple bands, she also taught music to younger children at this institution.
Wow, she was gifted.
Jillian played both solo and with her bands in many local spots, including the Stone Pony. Have you ever heard of the Stone Pony?
I've been there.
You have? Why didn't you invite me? What did you see there?
I don't remember. I feel like I just went to a bar. No, this was like, I don't even know how many years ago, maybe 15, 17 years ago. I just remember going to a bar.
Okay.
I remember because it was famous, the Stone Pony, and I got a T-shirt or a tank top.
The Stone Pony is very famous. I saw Third Eye Blind there a couple of times, but they have had some huge names such as Maroon 5, the Lumineers, the Wallflowers, Counting Crows, and so many others.
Sorry, wasn't it one of the places Bruce Springsteen originated? Wasn't that why it was famous?
That was his old stomping grounds, yeah.
Okay.
She also played at other well-known local venues such as Asbury Lanes and Count Basie Theater. That's right in Red Bank. You've passed it many times when you were here, Meghan.
I can't say I remember that one. Sorry.
No, that's okay. It's a theater that brings some incredible shows. So she's really on the music scene here in Jersey for sure. She also played some gigs in New York City.
Wow.
So in 2022, Jillian initiated a service project called Playing It Forward. And this is where she would play music at local establishments and events, and she would donate all of her tips and proceeds to various organizations that would help other musicians in need, including children with inadequate access to instruments and music education.
Wow.
And again, she's only 18 years old. This seems like a lot for an 18-year-old, but that's not all. She also became a member of the Young Women's Leadership Committee of Wall Township, and she was the recipient of the 2003 Women's Leadership Committee Scholarship Award. Now, she graduated Wall High School in June of 2023, and she enrolled with Belmont University, which is in Nashville, Tennessee. And this is where she would head off in the fall to major in music business.
Really had a good trajectory.
She did, Meghan, but only 2 months into her freshman year, Jillian would become a victim in a tragic event. The afternoon of November 8th, 2023 was a beautiful autumn day, and 18-year-old Jillian decided to go for a walk at Edge Hill Community Memorial Gardens. Now, this was a park about a mile away from her campus. This was around 2 p.m., and the park was pretty empty. She just put in her earbuds and took a little walk listening to music. She walked on one of the park's paths, and then she headed to a track area. And she just headed over to a track area. Now, as she walked the track in the park, out of nowhere, Jillian was struck in the head, rendering her instantly unconscious. And unfortunately, around an hour would pass before another walker found Jillian and called for help. First responders found that Jillian had been shot in the head and was in extremely critical condition. Jillian was rushed to nearby Vanderbilt Hospital, but sadly doctors were unable to save her, and she succumbed to her injuries a short time later. Now, an investigation was opened very quickly because they wanted to find out, where did this shot come from? And was Jillian the target? Who would have done this? Who would shoot at a college freshman taking a walk in a park in broad daylight? Mm-hmm. First, police wanted to track, of course, where that gunfire came from, and their sources led them to a public housing unit across the street from the park. Through the use of surveillance video and witness statements, detectives were quickly able to identify 28-year-old Shaquille Taylor as the man who had shot the gun. Later, during their interview with Shaquille, he readily admitted that he had been the one who shot the gun, but he wasn't shooting at Jillian. He was shooting at a nearby car that was parked outside of the park, and one of the bullets missed his intended target.
He's still confessing to attempting to shoot someone. Okay.
Yeah. And sadly, this was the bullet that hit Jillian as it blasted through the park. Ugh. And I just want to clarify something. It's not clear in any of the records if the car he was shooting at had people in it or if he was just shooting at the car.
Oh, I see.
We will get some more information once we hear what the charges are, but at this initial point.
Okay.
So I think before we go any further, and there's a lot to cover here, we need to talk about, who is this man, Shaquille Taylor? Well, I can tell you, Meghan, he was no stranger to law enforcement. Mm-hmm. Shaquille is what's known as a career criminal or a chronic offender. Mm-hmm. You see, he'd been apprehended multiple times prior to this incident, and his record goes back to 2010 when he was just a juvenile.
Okay.
But things got most serious for him when he was charged and found guilty of robbery and assault, and this was back in 2015. For these charges, he served 11 months and 29 days in jail. Then, in 2016, he was arrested for aggravated burglary before being convicted on a lesser charge of contributing to the delinquency of a minor. Now, it's unclear how long this sentence was, but we know that clearly there's an escalation of violent behavior.
Yeah, that's a very short time for a robbery, too. I'm assuming he didn't have a weapon, and that's why. But if that robbery, 11 months, he had a weapon, that's way too short.
Yes. Well, more recently, in 2021, he was charged with 3 counts of assault with a deadly weapon. Because in this incident, he shot into a car where a mother and her 2 young children, ages 1 and 3, sat. And again, it's unclear if he was targeting these individuals for any reason, if he was trying to rob them. It's not really clear, but either way, this is someone that's clearly a danger to society.
Yeah, it doesn't matter. So where did those charges stand at the time of this crime?
This is where things get interesting, and you're going to be really angry to hear this, because I think everyone listening or watching knows, well, this is a red flag, and this is someone who should be detained. He is clearly a danger to society.
Yeah.
However, Meghan, he was not held. He was released to the community. You see, he was found incompetent to stand trial.
Yeah, but if you're found incompetent to stand trial, you usually have to be remanded to a psychiatric facility or mental health facility until such time when you can be restored to competency.
Yes, usually that is exactly what happens. Well, here in this case, that's not exactly how things played out. But before I get into the specifics, I want to take a minute to explain the clinical legal issue of competency.
Okay.
And I'm going to geek out a bit, but I've heard from our listeners that they love when we geek out, so you asked for it. Actually, I just taught about this last week in my forensic psychology class, so it's really at top of mind for me and an area that I'm super interested in.
Yeah.
What is competency to stand trial? So in our country, competence to stand trial means that an accused must have the capacity to function meaningfully and knowingly in a criminal proceeding. An individual may be formally held if they are deficient in one or more of the following areas. In other words, they can be civilly committed. Mm-hmm. So an individual needs to understand legal proceedings. They need to be able to communicate with their attorney. They need to be able to appreciate their role in the proceedings, and they need to be able to make legally relevant decisions. And this is very important given that defendants must be able to understand the charges against them so they can participate in their own defense. And of course, the purpose of this is to just increase the likelihood that there will be a fair, just trial. Mm-hmm. And I spent a lot of time with my students about this because I also teach insanity. So I just want to point out here that competency has to do with one's present ability. Insanity is one's mental state at the time of the offense. Competency is one's mental state at the time of criminal proceedings. So one doesn't necessarily have something to do with the other. Mm-hmm. I was just talking to my class about cases where someone can be found incompetent to stand trial, but they don't meet the definition for legal insanity, right? It's two totally separate things.
That just happened with Lori Vallow's case.
Yes, it did.
Remember, she was incompetent for quite some time, restored, but there was no meeting insanity.
Yep. Because that at the time of the crimes that she committed, it was found that she was not insane at that time. Right. Also, in our country, it's not morally acceptable to punish someone if they can't understand why they are being punished. Mm-hmm. And Meghan, I'm sure you teach this landmark case that I'm about to talk about. Do I even need to tell you what I'm about to say?
Is it Dusky v. United States?
It sure is. Mm-hmm. One of our favorite landmark cases, yep. Dusky versus the United States in 1960, is the case that established an accepted national standard for competency. Now, there are minor jurisdictional differences, as there are with a lot of our laws. But this particular case on the federal level ruled that a defendant must have, quote, sufficient present ability to consult with one's attorney with a reasonable degree of rational understanding and a rational and factual understanding of the proceedings against them. How is sufficiency judged? Well, that's, I think, one of the issues because it's quite subjective, right?
Yes.
But luckily, many courts have provided additional specific areas that can be assessed that are relevant to one's psychological abilities related to the current situation. Mm-hmm. Under Dusky, the presence of a mental illness or intellectual disability does not guarantee that a defendant will be found not competent to stand trial. The crucial question is whether the disorder impairs their ability. You can have some mental health issue or cognitive impairment, but that doesn't necessarily mean that you're not competent. Again, it all hinges on the ability to participate knowingly and meaningly. While anyone in the court can raise the issue of competency, like a judge, a prosecutor, or a defendant, or a defense attorney, it is typically raised by the defense, mm-hmm. but at the end of the day, it's up to a judge to decide whether or not to even assess one's competency. And if a judge decides to move forward, then a mental health professional will conduct an examination. When assessing competency, most states use preponderance of evidence, and that simply means that a defendant has to show that it's more likely than not that they are incompetent. Again, this is subjective, but the reason I bring it up is because there are a few states that require clear and convincing evidence, but not Tennessee. So Tennessee is that looser criteria. Okay. Competency is a tough standard to meet because about 70% of defendants who are referred for evaluation are actually found competent to stand trial. In most cases, when a defense attorney brings up the issue of competency, an assessment reveals that they are in fact competent. So in other words, most cases are moving forward at this time. So it's like the insanity defense. It doesn't happen very often.
You said 70% though? That means 30% of defendants are not found competent?
That's correct.
Is that like a United States total or is that like a Tennessee? Because that number is actually way more than I would have thought. I would have thought most defendants are deemed competent even if they're not, but that's very interesting.
The interesting thing about that, Meghan, is if you look at it in the inverse, that means 30% of people are found not competent to stand trial. Mm-hmm. But the source I use, which we cite at the end, did say that when there's a rigorous examination, that number goes down to 10%.
That's exactly what I would have thought. Okay.
But in the literature, you're going to find a pretty big range, which I think is an issue in itself.
Yeah, I didn't know that.
Now, if a defendant is found incompetent to stand trial, things get a little more complicated. And that's what's relevant in this case. So for non-serious crimes, the charges might be dropped in exchange for seeking treatment. Mm-hmm. In other cases, however, a defendant can be hospitalized in which they have to be treated and restored to competency, which at the time of restoration, then court proceedings will continue. And things are very different today than they were historically, because prior to the 1970s, defendants who were found incompetent were often confined in a state psychiatric center. And this could be for excessive amounts of time,
Right.
sometimes even exceeding the length of what the sentence would have been if found guilty.
Wow.
Do you teach this next case I'm going to say also?
Is it for competency?
Yes, this one gets a little more into the weeds, but in 1972, the Supreme Court case of Jackson versus Indiana ruled that a defendant cannot be held more than a reasonable period of time. What does reasonable mean? Well, in most states, it's going to mean that the time of civil commitment cannot exceed the maximum punishment for the crime in which they're facing charges for.
Right. So I know the case. No, I don't teach that one, though. Nope.
Okay. But I have to say, in most cases, when someone is found incompetent, and I'm not sure if you know how long it was in the Vallow case, but usually it takes about 6 months to restore competency. And basically that just means an individual goes to a mental health facility where they're giving therapeutic intervention, which often means they're being medicated to restore their competency. Do you recall how long it took in the Vallow case?
It was a matter of months, 6 to 9, something like that. So it probably fits with that.
And you know, Meghan, one more little caveat before we get back to the story, I promise. But I just want to point out there are some rare cases where a person can be found unrestorably incompetent.
Yes.
And that's where someone could be civilly committed to a state forensic hospital. I mean, This is hard for the state to do because it could be a huge violation of an individual's rights. But if the state could show that a person is mentally ill and either imminently dangerous to self or others, or so gravely disabled that they'd be unable to care for themselves, then they are able to.
Yeah, that's kind of the essence of civil commitment. So, yeah.
Yeah. All right. So thanks for letting me have my moment of, of glory of going through all of that. But I think it's time to get back to the case of Shaquille and see what happens here, because this is going to shock you. Now, in this particular case, a court-appointed doctor testified that a series of evaluations showed that Shaquille Taylor, quote, does not have decisional competency and further training/medical intervention would not change the outcome. Court documents also revealed that he functioned at a cognitive level of a kindergartner as he had had a brain infection as an infant, which was caused by pneumonia.
So he's not competent, and they're saying he can't be restored to competency.
Yep, you're absolutely correct.
Okay.
That's what they're saying.
Okay.
But another court-appointed doctor concluded that Shaquille was incompetent and not committable, while a third said that he did not meet the state's criteria to be involuntarily committed. So a quote from one of the doctors read, "In my opinion, Mr. Taylor does not possess adjudicative competency due to his intellectual disability and language impairment." Meghan, this particular assessment was conducted for the Tennessee Department of Intellectual and Developmental Disabilities. Okay, and it continues, quote, "He understands the allegations and recognizes that his liberty interests as the accused are at risk. He was easily confused with basic questions. There was limited ability to provide his attorney with relevant information about his case." So after hearing the findings from the various doctors and the various assessments, criminal court judge Angelita Blackshear Dalton wrote that the court had, quote, "reached the limit of its authority and thus granted the dismissal of charges."
Oh.
So this means that Shaquille Taylor's 2021 charges of shooting into a car with 2 children and a woman in it, they were all dismissed and he was released back into the public instead of being committed to a facility where he would regain competency.
So he's kind of a loophole then, what you're saying, because they didn't think that he could ever be restored to competency, but yet he didn't understand the charges, so he can't be tried in court. So what to do with him? Is that kind of the issue, if I understand it?
You understand it perfect, Meghan. And this is one of those cases where you have someone who's not competent enough to stand trial, but too competent to be civilly committed. And I think this is a gray area that no one was prepared to deal with, because this would be a decision that would have fatal consequences.
Whoa, I've never heard of this happening before.
And this wasn't the first time that Shaquille's mental competency was called into question. So we're talking about someone that had a history. For example, in 2010, when he was a teenager, he was referred to the Department of Intellectual and Developmental Disabilities, and a doctor found that he was, quote, incompetent and not restorable, meaning that his disability was not going to get any better. And based on his actions, it hadn't gotten any better. So it was known that at this point, this child had issues that were not going to get any better. So I'm not sure why he was not given services at this point, or if he was, why they were not continued.
Okay.
As you could imagine, after Jillian's death, the state's view of competency was called into question, and this is the issue that was at the forefront. Nashville District Attorney General Glenn Funk described the current state law for involuntarily committing someone is, quote, nearly impossible, and it impacts public safety. He continued, quote, the law must be altered to accurately balance an individual's needs with public safety. He said in a statement, at the same time, Tennessee must provide more beds and staffing resources to handle dangerous individuals. So again, according to Tennessee law, he was not competent enough to stand trial, but too competent to be committed. So what do you do in a situation like this?
I'm actually at a loss right now. Usually I have a pretty firm opinion, or this is what you could do. I'm not sure. I find it infuriating, but I'm not sure. This is one of those, it is a loophole. It's a gray area, but one probably that's hard to anticipate. So I don't sympathize, but I see the challenge here. So I don't know what the answer is.
I know. And this is another area I teach in forensic psychology, because we often talk about the conflict between civil liberty and individual rights and public safety.
Right.
So I think it's very relevant here, because I don't think anyone wants to live in a system where people could be involuntarily committed by the state. However, we have to weigh public safety as well.
Yeah.
So what do you do here?
I mean, usually public safety trumps all. That's almost always.
It almost always trumps all. But again, they were looking at the federal and state law on the books, which said mentally incompetent defendants cannot be prosecuted.
Right.
However, it is rare that if someone is deemed incompetent, that they are released and not sent to a forensic mental health facility. And I think that's where the disconnect comes in, is why was he released? Why were these charges dropped?
Yeah, no, that's the disconnect. Absolutely. I agree with you. I'm sitting here. I'm almost a little bit mind blown by this still.
Yeah.
Because I've just, again, never
There's still a lot more also
heard of this.
And as we now know, after release, he did not stop his criminal activity.
No.
And besides Jillian's death, he was also arrested again on September 21st, 2023. So recall, when he was shooting into that car, the whole competency issue, that stems from a 2021 case. So he was back in the community. And then in 2023, he was picked up driving a stolen car that had been carjacked by two men that were wearing ski masks. Now, he claimed he was not involved in the carjacking, but he was charged with felony auto theft and later released on a $20,000 bond.
Actually, I'm not a little bit unclear as to why he doesn't meet some civil commitment standard now, because I guess it is a state-by-state difference, but he is a chronic career criminal who poses a very serious danger to the community, and he seems to have some type of mental health abnormality that prevents him from conforming his behavior to the law, which, as I understand it, meets most civil commitment standards. It's clear that he needs to be removed from society. I don't know a better way to do it. He's a real public threat, unfortunately.
Now, I just want to reiterate this again, Meghan, right? There was those 2 years, and I don't know if he didn't get in trouble. It was maybe minor infractions. It's possible he was living a law-abiding life between... Remember, when he was released, charges were dropped for that 2021 shooting. Now, in 2023, when he's picked up again, they release him on $20,000 bond. And this is somebody who, again, has a criminal history. And for this particular charge, he was due to be back in court on November 3rd, but he failed to appear, which resulted in a bench warrant.
And he's the person for which this kind of bail shouldn't be an option.
Well, Meghan, 5 days later, Jillian Ludwig would be shot in the head. So he was out on a bench warrant when this crime occurred. Now, why wasn't he apprehended in those 5 days? Because there were 5 days between when he didn't show up for his court appearance and for when Jillian was shot. So there's a lot of questions surrounding, was he that difficult to find if he was just hanging around in, the housing project where they knew he was going to be? What happened in those 5 days that he was not taken in?
I don't know. I don't know how many bench warrants are out. You know what I mean? Like, I don't know how hard it is, what their resources are, what their staffing is. Like, I'm not going to, I mean, he should have been, but I'm not going to say that there couldn't have been any number of reasons why he wasn't. I'm just disturbed now that he was also given a $20,000 bail. He's like not an appropriate candidate for bail.
Yeah. So there's really two issues when it comes to what's going on with law enforcement here in Tennessee, because you had the issue of competency, which alone would have been enough to outrage people.
Right.
But then the fact that this happened while this chronic, persistent offender was on bail and did not return to court. So this creates a lot of issues for the local and state police here.
It's the very reason why bail reform gets a bad name, because he was the wrong candidate for it. Ugh.
And people like him ruin it for people that actually do well on bail.
Oh, this is terrible.
Yeah, so Shaquille admitted to shooting the gun on November 8th, and he was arrested, and he was initially held on $280,000 bond on failure to appear, aggravated assault, and evidence tampering. I'm not sure exactly what the evidence tampering is about, but I would imagine he tried to get rid of the firearm.
Mm-hmm.
In March of 2024, Shaquille Taylor was indicted on first-degree murder and evidence tampering charges. Another competency will be held for the new charges, but as he awaits competency hearings for these new charges, legislation moves through that would more easily allow authorities to commit a person facing criminal charges who is not mentally fit to stand trial. And this would be to commit them into a mental health institute. Jillian's family would probably say it's a little too late, but at least now they're going to take this seriously. But while Shaquille had finally been indicted for a crime, it was at the expense of Jillian Ludwig's life.
Right.
As stated in Jillian's obituary, quote, Jillian was a radiant and talented young woman full of enthusiasm, compassion, and love. Her music, service, and positive attitude made the world a better place. In her short 18 years, Jillian made a remarkable impact on countless people, and her spirit will continue to bring light to the world. And Meghan, she was so talented that we're going to post a video of her playing and singing on our YouTube channel, where you could get a feel for just what a beautiful artist this woman was.
That's good. I was going to look it up after anyway, but no, I'm glad. We should share that for sure.
On December 30th of 2023, on what would have been Jillian's 19th birthday, her friends, family, and fellow musicians gathered in the Grand Arcade inside Convention Hall on the boardwalk in Asbury Park. And this was for the Play It Forward for Jillian event. Mm-hmm. Now, all of these proceeds benefited Jillian's Play It Forward campaign, which again raises funds for kids seeking music education opportunities in the area. And Jillian's parents, Matt and Jessica, have become advocates for changing the laws around how courts can deem perpetrators unfit for trial.
Yeah.
The bill, dubbed Jillian's Law, expands the definition to include a person who has been found incompetent to stand trial in a criminal proceeding. It also establishes a rebuttable presumption that a person who has been charged with a criminal offense and found incompetent to stand trial poses a substantial likelihood of serious harm. And lastly, the bill prohibits the purchase or possession of a firearm by a person who has been adjudicated as mentally defective. And that's quoting from the bill.
Right.
Lastly, this legislation would also require that individuals who are deemed incompetent to stand trial be entered into the National Instant Criminal Background Check System. And this serves as a database for people prohibited from buying or owning firearms.
It was just, the reason I smiled is because I had a student who did a presentation on this just yesterday on the NIC system.
Oh, really?
Yes, and how it could be really effective, and it has been, but there are substantial loopholes, and I think this was one of them, so interesting.
Yep. Jillian's parents, Matt and Jessica, also spoke before the Criminal Justice Subcommittee addressing the proposed law, saying, quote, "We felt it was important that we show our faces and represent Jill because she can't herself. And we wanted to make our case for why this reform is needed and really just to tell our story and have people hear it directly from us." As of this recording, it was recommended for passage by the Senate Judiciary Committee, so it will hopefully be passed. As we know, these things often take a lot of time, but it might be expedited given the situation. Now, this is one of those cases that it's really hard to wrap our heads around what happened. And I often tell my classes when we talk about victimization and victimology, I don't like to ever say it's the wrong place at the wrong time.
Right.
But I think in this situation, that is a relevant explanation, at least as far as trying to understand the victimology here. Would you agree?
Yes. The most unfortunate, and yes, I can't think of another way to really describe it. Just such an unfortunate tragedy.
Yeah, I mean, Jillian, it was broad daylight. She was in a safe area, and she wasn't even obviously approached by the offender. This was a total random shooting, unfortunately. I think another point that's worth discussing, Shaquille Taylor was indicted on first-degree murder charges. And first-degree murder is often premeditated and deliberate. But in Tennessee, they consider two main types of killings to be first-degree. And that would be, of course, your premeditated deliberate murder, but also
felony murder.
Felony murders. And felony murders are murders that are committed during a violent felony. So here, of course, we see the latter because there is absolutely no evidence to suggest that he planned to shoot and kill Jillian.
Sure.
However, Jillian's murder occurred during the commission of a felony, which was carjacking. And in Tennessee, carjacking is a Class B felony.
We're not even going to tackle felony murder, though, in this episode. We do in others, but I noted.
Oh, well,
I understand.
Well, normally, you know, I am not a supporter of felony murder. However, this case may have me rethinking things. I mean, we talked about Liesl Allman. In Liesl Allman's case, no, I don't think felony murder applies. Or Tyra Patterson's case, if you recall, I think that was a Patreon exclusive where we talked about another felony murder case that was unfair.
Yes.
So, Meghan, what do you think? Did this system get it right? I mean, before I let you answer that, of course, this remains to be seen, right? But I think as of yet, no, the system has not been getting things right along the way here. And unfortunately, Jillian was the consequence of all of these issues in the system.
Yes, it seems to me in this case, the system was not designed around this. It seems like a flaw, right? The system wasn't designed around this sort of small number of cases that probably involve the type of offender that Shaquille was. However, we have to anticipate almost all types of offenders and all types of scenarios. So what it strikes me as is, unfortunately, no. Had he not been released, likely Jillian would be alive. You know, this is such an unfortunate tragedy. So I do believe there's a need to address this in the system. I think a bill would be appropriate. I don't know how long they planned. You know, I'm always in favor, too, of kind of a strategic planning of a bill that takes a little bit long-term planning to identify the real areas that are lacking, who it's affected, you know, what the best way to solve it is. So I hope that this plan is just, or policy is a well thought out and well planned one, because it'll have a better chance of success. But yeah, there was a need that was lacking here, and it's the reason this young woman is dead.
I mean, there's also a whole other issue that we could attack, though. Should he have been found incompetent to stand trial? I'm not so sure of that, because although he did have they said he had the intellectual ability of a 5-year-old, which, of course, anyone who has that should not be in court proceedings.
Right.
But Meghan, I didn't mention, but he had a job. I'm pretty sure he lived on his own. He had a girlfriend. He purchased and used guns. I mean, that doesn't seem like someone who has the mental capacity of a 5-year-old, does it?
No, it does not, actually.
So that's problematic, too. But I don't know how we rectify that.
Well, I don't know to what degree. You know, also, they're saying mental capacity of a 5-year-old. Is that one assessment? Does that mean as it pertains to one area of his life and not all of the others? That's always used as like a blanket, but it might not be a blanket.
Yeah.
But still, if findings in multiple areas of his life are that he's competent to do things that the average person can do, then that sounds inappropriate. I'd also like to say that the bail, totally inappropriate and really disheartening to find that he was released on $20,000 cash bail, which doesn't address at all his potential danger to the community or flight risk.
Nope.
So I think that was a huge mistake as well. That was just as detrimental.
And it'll be interesting to see if he's found competent to stand trial or if they're going to civilly commit him. But I would bet that, you know, given his history, I would not expect the prosecution to go easy on him.
No.
I don't think he would be offered a plea that would be attractive at all.
No.
But it will be interesting to see where this goes, because I think it's clear that he has an intellectual disability or there is some sort of competency issue. But again, that doesn't mean he should be on the street, because he's clearly a danger to society.
No.
And he's proven that. Unfortunately, he took Jillian's life and proved that he is, in fact, a danger to society.
And there's no reason to believe that he was released, that he wouldn't go on to continue in a lifelong criminal career. So I think there is no way that this is a man who is fit to be released into the community. Unfortunately, he just poses too much of a threat. So one way or the other, he has to be detained.
And I suspect he will be.
Yeah.
And I know I'll be keeping an eye on this case. As of now, his competency hearing is scheduled for early summer of 2024, but, you know, that's always subject to change. I encourage all of our listeners and viewers, though, to check out the GoFundMe page that has been set up to honor Jillian. As of today, there's over $140,000. As the site reads, quote, "In loving memory of Jillian Ludwig, whose bright smile and infinite enthusiasm brought light into our lives, we are asking for donations to help the family with medical and funeral expenses and other endeavors they are considering in order to honor their beautiful daughter with projects in her name to further her desire to give back. Jillian's life was a symphony of joy and love that was tragically cut short as a brilliant student, musician, and most importantly, an irreplaceable part of our family."
Oh, that's lovely. She sounds like such a beautiful human being, too.
Yeah.
Oh, Amy, this case it's really devastating. And at the same time, it brings up such an interesting area of possible reform that I never would have thought of. So thank you to your sister-in-law. I'm glad she put this on our radar.
Yeah. And I hope that other states learn from what happened in Tennessee and not wait for a tragedy to happen before they amend their laws.
Agreed.
Okay, well, that's all we have for today. Thank you so much to our listeners for joining us today, and we hope you will join us on the next episode of Women in Crime.
Women in Crime is written and hosted by Meghan Sachs and Amy Shlosberg. Our producer is James Varga. Script editing is by Abagail Belcastro. Audio editing is by Siler Burr and Jose Alfonso, and music is by Desert Media. If you enjoy the show, please remember to follow and leave a review. You can also support the show through Patreon, where you can get access to additional ad-free content such as exclusive full-length episodes, lectures, a book club, and virtual happy hours with Meghan and Amy. For more information, visit patreon.com/womenandcrime.
Sources for today's episode include ABC News, Fox News Nashville, The Tennessean, Jillian's Obituary, CBS, the Asbury Park Press, NBC News, tennessee.gov, and WSMV.com.